So good afternoon, Julian, Lynn, Neil, Raymond, and everyone else that's in attendance today. Thank you for giving up your time. I really do appreciate it. And as I mentioned, and without further ado, what I'd like to do is to introduce John and Liz from Stewart Title, who look after Northern Ireland on behalf of Stewart Title. So welcome to you both. If I may, John, I'm just looking at this slide here and talking about sort of bespoke policies, etc. I do know that you have a sort of an online presence, don't you? So
Yeah.
the sort of standard policies, anyone that's interested can simply go online and complete proposal forms. Is that right, John?
That's right, Ian. What I always think is that don't be too concerned about going online. It's a really straightforward process if you can basically tick the boxes for the assumptions. It's straightforward. I actually had occasion to use it as part of a testing process last week. And the interface that I've got as an underwriter is different from what the clients have got. So I had to use it from the client's point of view for some testing purposes, and I was really surprised how easy the whole thing is.
Brilliant.
I mean, when people say it's a matter of clicking 4 or 5 buttons, as long as you can click those 4 or 5 buttons, that's how easy it is.
I think even I might manage it, John. I think even I could manage it.
Well, more than you, Ian. Even I could manage it, and I'm not. I'm IT illiterate at times, so I would encourage people to use it.
Fantastic.
If you don't get accepted on it, your request is transferred to an underwriter immediately, and you would be contacted very soon thereafter. So the other thing I'd like to reiterate from what you've said, Ian, is please ask questions, even issues that come up in the course of your working day, or if you'd like us to look at, say, for example, a new case that's come up that affects property law, or indeed an old case that you think would be worth exploring further.
Yeah, thanks for that, John. And I mean, the other thing I think is important, John, I was just talking to Robert Kelly yesterday, and Stewart Title have recruited a number of new underwriters on the basis, A, of how busy you are, and B, to have capacity to take on new work. So in addition to the website and the availability of online policies, and John and I have both sort of agreed, despite our lack of IT skills, even we could manage. It's also important to note that bespoke policies are capable of being created. So as mentioned on the slide here, Stewart Title have a very, very experienced underwriting team that has recently been expanded that can help with regard to bespoke policies. And I was talking to Robert yesterday, John, about this, and I know that you and Liz have considerable experience with regard to the Northern Irish marketplace, and that you can provide assistance and point people in the right direction with regard to the creation of bespoke policies. So those of you that are familiar with Stewart Title, and I'd be interested to see if anyone in the chat box could say, yes, we've used Stewart Title, that'd be great. Do be aware that in addition to standard policies, bespoke policies can be created. And those of you that haven't utilized Stewart Title in the past, again, do be aware that the company and the organization isn't a hard sell. It's just there to provide a service to the legal profession. And I think that's evidenced by the fact that they facilitate me to come along to these sorts of events to discuss issues. So you don't have to sort of sign a contract or do anything. I think you have to sign up to be able to use the online service, but that's a dead simple exercise, and you can just complete proposals as and when necessary. And I also know that John and indeed Liz are more than happy to visit you in your offices to discuss your needs and requirements, and also to set up any compliance issues associated with using Stewart Title products. So thanks for that, John. That's great. I might call upon you to explore some examples of bespoke policies, etc. you've taken out in a moment or two. Contact details, of course, important, are on slide there. We've got Elizabeth's contact details. John, if you like, you can put your contact details in the chat facility. But if you want to speak to John or Elizabeth or Robert, you've got their contact details there and a sort of an address to enable you to sign up for Stewart Solutions. Okay, so that's my email address, ian@iqlegaltraining.com. And the important thing about the forum is that you may have questions that are sort of burning issues today, but as John was touching on, you might, during your sort of weekly transactional work, hit across something that you haven't seen before or want some help or guidance relating to it. And if that's the case, make a note or send me an email, and I'll endeavour to make sure the topic or the issue or the problem that you have is something that we look at the next forum. And on that note, what I wanted to do today was to talk about three things, all of which I think are relevant and pertinent to get the ball rolling. The first thing I want to talk about is how we scope the retainer in connection with residential conveyancing transactions. Those of you that haven't had the misfortune of listening to me in the past won't know where I come from with regard to residential conveyancing. And I come at residential conveyancing from a very defensive position in that I'm horrified about negligence claims or client complaints. The reason for my horror is the fact that I see issues and problems almost on a daily basis from firms that seek guidance or assistance. So these are solicitors or conveyancers who are encountering problems with regard to their work, where errors have been made. And then secondly, insurers, that these are professional indemnity insurers that will contact me and say, hey, look, we've got this, what do you think? Or we're getting a number of claims relating to this. Why? Are there measures that we can take or recommend to be taken by our insured to try and prevent claims arising? So bearing that in mind, I am frequently scrutinizing firms' retainers and looking to determine whether or not the retainer is providing them with protection. And secondly, looking at them to ensure that there is sufficient clarity so that clients understand what's being done and what's not being done. By the way, James, I notice you've joined us today. Thanks for that. That's great. I hope you were here at the start, but if you have any topics for conversation, please put them in the chat facility. And again, for anyone that has any recommendations for speakers or anyone you'd like to come along to the forum in the future, let me know and we'll try and organise that for you. But going back to scoping the retainer then, okay? So we all have a retainer document or an engagement letter or email that goes out to the client. It's important that that's kept under review. It's important that we consider it and look at it from a client perspective. In other words, what would the client think if they received that document? Does it clarify what the conveyancing process entails? Does it clarify our role in the conveyancing process? And my guess is there's an emphatic yes to both of those questions. But what I'm really interested in, does it also tell the client what we're not going to do, the limitations of our role, our relationship with third parties, the potential pitfalls of the conveyancing process? Does it set realistic client expectation with regard to our role? All of these sorts of things I think are really important. And rather than just talking about generalities, let's look at specifics. So item number one, would you, as a conveyancer in the retainer, explain to the client that you won't be advising the client about the commerciality of the transaction? By that, I mean that you wouldn't be saying to a seller, I think you're selling this too cheaply, or if you're acting for a buyer, I think you're paying over the odds for this property. Would you explain to a buyer client that as part of the due diligence process, you won't be inspecting the property? Or that if you are inspecting the property, what the purpose of the inspection would be and what you'd be looking out for? Would you explain to the buyer client the concept of let the buyer beware and caveat emptor, etc., etc.? So first things first, everyone that's attending today, when was the last time you looked at your retainer or your engagement letter? And the second thing is, when we're onboarding clients, do we sort of audit the clients that we're taking on board or our target audience? Just looking at professional indemnity insurers, one of the things that they're very keen to talk to me about is asking me to talk to firms about gathering data with regard to client types and transaction types and assessing risk. So you might have a retainer that you've used for the last 10 years, and the retainer is aimed at the client that calls into your office and that you're going to have personal contact with during the conveyancing transaction. Well, what happens if all of a sudden there's an influx of clients that are instructing you, courtesy of your website, and perhaps that are sort of clients that aren't local to you, and therefore you're dealing with the clients on a sort of virtual basis? Well, do you amend the retainer to take into account that type of client? So it's all well and good having a retainer. It's important to keep it under review. And in keeping it under review, it's imperative that we look and assess at the sorts of clients that we're attracting, and indeed the sorts of clients that we're hoping to attract. So insurers are very interested in what our retainer says. I look at those general points that I made a little earlier. They're very keen to look at, does the retainer fit our client type and our client profile? And if we're looking to attract new clients, do we think about what the retainer does and doesn't do in connection with that new type of client? The next thing that's important, and again, I'd welcome views on this, is to watch where we've told the client what we're going to do and not going to do, and we've set realistic client expectation. Then in the heat of battle, we're required to do something which we said in the retainer we wouldn't do. Let me give you some examples. We may have in our retainer said to the client, we won't be inspecting target property. But then during the transaction, if we're acting for a buyer, there's an issue with regard to a boundary, for example. Well, in those circumstances, the survey or valuation might touch on the fact there's a problem or issue. The seller might have disclosed the existence of the problem, or the buyer during inspection might have highlighted a problem. So in those circumstances, we do feel it's appropriate to actually visit the property to check what the boundary issue or boundary problem would be. If in the retainer we've said we're not going to do that, if we are now going to do that, it's important that we do two things. One, we expand the retainer so the client understands that notwithstanding what we said in the first place, we're now doing something. Number two, we explain to the client the purpose of the inspection, and here we are expanding the retainer, but then contracting it to say we're inspecting purely to look at the western boundary because the surveyor and you, Mr. Client, have told us there's an issue with regard to what appears to be a boundary alteration, and we can't from photographs or can't from plans, etc., get our head around just what's happened or what could have happened and the legal implications. But all we'll be doing is inspecting the property for that purpose and nothing else. So again, as far as scoping the retainer is concerned and the commerciality point, you would be required, if you became aware that if you're acting for me in connection with the purchase of a property on the outskirts of Belfast, if you were aware that I appear to be paying double market value, and the reason you know that is you've acted on a purchase of a property 3 doors down that appears to be very similar to the property that I'm purchasing, there would be an expectation on you to say to me, Ian, you may be paying way over the odds for the property you're purchasing. Even though in the retainer you said you wouldn't be advising on commerciality, what you are aware of is potentially so materially adverse to my interest that you're under an obligation to disclose it. So again, in those circumstances, you'd explain, in the retainer, I said I wouldn't be advising you on commerciality. However, this has been drawn to my attention, and I just want to make sure that you're aware of it, and that I'd recommend that you have another valuer or surveyor have a look, just to make sure the purchase price appears a reasonable sum and that you're not paying too much money for the property. So this point about scoping the retainer and then managing the retainer is important. The next point that's important is making sure that the retainer is consistent with the report on title that you send to the client pre-exchange. So again, if you're saying you're doing things in the retainer that you're not reporting on, alarm bells would ring. And if you are reporting on things that you said in the retainer you're not dealing with, again, alarm bells would ring for me and indeed your insurers. The last point that I'd make with regard to retainers that I think is so important is to make sure that as far as the retainer is concerned, the document that you are using is consistent throughout your office and offices. Just recently, I did some work which is ongoing for a large firm of solicitors that has 6 branch offices, and their retainer and their report on title are different for each office. And what really got me sort of annoyed and amazed was the fact that some of the officers had variations of the standard documents. So in essence, when you looked at it from a distance, you had a firm that had, I think it was about 15 different separate types of retainer and about 20 different forms of report on title that could be used for the same transaction. Well, that's ludicrous and scandalous, to be honest with you. If an insurer found out or a professional body found out about those variances, which were variances from a sort of standard precedent, alarm bells would ring. Okay, so anyone got any questions about the retainer then? I'm going to look at some case law before we finish that sort of harks back to some of those points and just shed some light on where issues or problems can arise relating to them. The next thing I want to talk about is something that's on a hot topic no matter where I go, no matter who I talk to, and that's money laundering and AML issues. And again, I've just been looking at the National Crime Agency and its website about money laundering. And what they seem to be saying is as follows. A, the obvious, and B, the not so obvious. A, the obvious, the need to look at sources of funds and to what has been described by a colleague of mine as chasing the money. So if you've got a client that's purchasing a property and they've got a £50,000 gift from a great aunt, where does great aunt get that £50,000 from? And if that £50,000 was an inheritance to her or a gift to her, where's the documents that sit behind that explanation? And where that £50,000 is derived from some form of income, has tax been paid on it? So again, it's not just simply asking the clients where's the £50,000 gift coming from, and then checking from Ant that it is a £50,000 gift from him or her and from a bank account to a bank account. We've got to do more than that. So that's the first part. The thing that's really scary is where we are concerned that the risk associated with money laundering is high. So going back to my scenario, the clients that have instructed us on the purchase, we've identified as high-risk clients for whatever reason, or we identify that great aunt is, or auntie is a high risk with regard to money laundering, then we've got to perform enhanced due diligence. And enhanced due diligence is asking ourselves, does this £50,000 gift fit with the lifestyle, circumstances, wealth, employment, background of aunt or whoever's providing the gift? Or where our clients are saying they've amassed £50,000 of savings or gained £50,000 from playing the stock market or something of that nature, is that consistent with the lifestyle of these clients? So where these clients are sort of high-flying business people, then it might be reasonable to expect that they would be able to risk £50,000 on the stock market. If, on the other hand, the clients were of relatively low income and were sort of undertaking manual employment or whatever it may be, and perhaps had been off work due to ill health, etc. So means are limited, circumstances difficult. Does a £50,000 fund for purchase of stocks and shares sit with that background? The answer to that would probably be no. So with money laundering, we've got to be so careful about assessing risk. We've got to be so careful about asking questions. We've got to be careful about making sure that we know where money's coming from and that there's proof of the source of funds, and that where there are high-risk clients, there's also investigative work being undertaken with regard to the source of wealth. So can I ask James, Patricia, Raymond, Neil, Lynn, Julian, anyone encountered any issues with regard to AML at the moment? And again, as far as risk assessment, are you sort of comfortable with undertaking risk assessments? Because I talk to people about it and they say, well, I'm not comfortable about it. I'm getting pushback from clients. I'm getting unhappiness from third parties where I'm asking about funds, etc. So what do you think? Have you got any examples of circumstances? I'll give you an example. If you think your client is low risk, and I would assess a client as low risk if this was a sort of conveyancing transaction where you've acted for these clients in the past, or your firm has acted from them in the past. So the transaction is consistent with previous transactions. If the clients are existing clients of your firm and they're coming into your office and they're in regular, steady employment, and they're saying to you they've got £20,000 worth of savings and they've produced for you bank statements showing the £20,000, I wouldn't be asking that client, where the client is saying, well, we've amassed £20,000 from savings that we put aside each month, for the client to show each and every penny of that £20,000 has come from savings, it's come from employment and is put into savings. What I would say to the client is, can you provide me with 3 bank statements, one showing the £20,000 sitting in the bank as of today, 2, a bank statement for, say, June last year, 2024, and perhaps at that stage there's £14,000 of savings in that account, and perhaps ask for another statement in connection with the previous year. So with the 3 pieces of evidence that we've got, the bank statements we've got, we have in essence evidence of regular savings, but we're not asking for proof of each and every payment that amasses that £20,000 in a savings account. So that's the sort of thing we need to do. But on the other hand, if we've got a high-risk client with a high-risk transaction, a client that's new to us, then in those circumstances, they would be high risk and the strategy would be radically different. Raymond, hi Raymond. We've had substantial times that we always chase the money and ask for usual 6 months of bank statements from anyone where money's moved, gets lots of kickback, but it concentrates on the mines. It does, doesn't it, Raymond? And I mean, the thing that gets me, right, is that, at the end of the day, we're doing conveyancing work and we're getting fees for that work. Some firms are telling me that the fees that they're charging from AML checks, etc., and sometimes more than the conveyancing fees. So where, Raymond, you've got, say, it's 3 or 4 different sources of funds that's come into the client in the last 6 months. Not only are you looking at the bank statements, and it's not just a question of getting the bank statements, Raymond, it's a question of checking them, but then also checking where these other introductions are coming from and from whom, and where they've got the money from as well. So it's a real issue, isn't it? And the important thing, in my view, is we've got to be able to show our workings out, as it were. We've got to show where and how our decisions are being made. And I think, again, that's important. So I see some firms where they do all that appears to be necessary with regard to checks, checklists, etc. They use external resources for that purpose. But then there isn't evidence that the fee earner that's dealing with the transaction has actually assessed risk or made a decision, or where there is medium or high risk, the file doesn't reveal that extra checks and measures are being put in place. So I think it's ridiculously unfair that this burden is being put on us. But then if you talk to the National Crime Agency, police forces, etc., they're saying, well, the reason that we've got all of this is that conveyancing was and remains a fantastic vehicle for money laundering. So whilst that still exists, I think you're always going to have this problem. Now, again, in England and Wales, there's a sort of move to have a sort of centralised client account so that firms don't have individual client accounts. And I wonder whether the thinking behind that is, A, to stop sort of solicitor or conveyancer fraud with regard to client accounts, but I also wonder whether this is a sort of a tactic to try and make sure that instead of money laundering issues being checked and verified by the lawyer, whether or not there's some form of plan to have some external agency, if there is a centralized client account, undertaking those checks, etc. Raymond, I know you're typing something else, so I'm interested to see what you've got to say. I would have queries and questions from the youngest listeners of the firm daily, if not every other day. Large sum payments, clients contaminating their own bank accounts by borrowing money from mum and dad, granny, etc. Yeah, again, Raymond, I've seen situations where, it's not fraud, right? But there's cash coming in and going out. And what you've got is the client is disorganized, or the client is undertaking sort of employment from various sources and income from various sources, some of which are traceable and some of which aren't. And again, in those circumstances, it is difficult. As you say, large lump sum payments coming in and out, it's suspicious, isn't it? Unless there's a sort of logic sitting behind it. And to find out what the logic is sitting behind it, it requires a deeper dive into the problem, doesn't it? So thanks, Raymond, for sharing that. Raymond, can I ask some questions? Are you using any external resources in connection with AML? So are you sort of outsourcing that work? And is anyone else? Smart search, yeah. And do you like that? Yeah. Are you finding that useful? And anyone else? Yeah, okay. Anyone else use smart search? Yeah, Joe. All right. Yeah, okay. Use Equifax. So, Patricia, did you look at smart search before you use Equifax? Because smart search seems to me is coming up very positively. Yeah. Okay. All right. Yeah. Okay. So it's so really, Raymond, this is a sort of source of wealth as well as source of funds facility, is it, Raymond? And Julian, you did the inquiry. So Julian, can you just shed some light on what that would? I mean, obviously it depends on the transaction, doesn't it? Right, and depends on the risk associated with the client. But if you had, say, a medium risk client, a client that was a sort of known to the firm, a transaction that was the sort of transaction that the firm had conducted in the past, but say the client had unusual sources of income, what would your inquiries involve, Julian? Yeah, so yeah, I think that's a good point, Patricia, that you use Equifax, but it's sort of supporting your own checks as well. So it's sort of another string to the bow, really, rather than relying upon it. And Equifax doesn't do international. So does Smart Search do international, Raymond and Josh? Yeah, it does. Okay. Right. In an international UK search. All right. So that's just UK, Josh. You couldn't do Europe, and you're adding it to your available tools. Yeah, good. Okay. And if you had Josh and Raymond and indeed Patricia, if you had a high risk client, right? Does someone in compliance then check, or is it left to the FIA to decide high risk? Okay, all high risk. Yeah, I suppose they are really, if you look at it. But we are supposed now to, aren't we, assess if you had a high risk client, what steps or measures do you then take? Does someone then review the AML or review your search? And that's interesting as well, Raymond. Thank you for that. Might pay us, to get someone from the Smart Search to come along, because it seems to me that there are additions to the sort of basic search. Is that right? And Patricia, you're lucky, yeah. So when you say small practice with firms that are known to you, clients that are known to you that will come into the office. Oh yeah, Raymond, reporting officer, get that. Yeah, okay. So I'm just waiting for Patricia, then I'm coming back to you, Julian, if I may. Yeah, mostly legal aid clients. Okay, right. Yeah, and Josh, you're doing your Smart Search with your own knowledge of clients. So it's sort of a dual system that you've got there. Okay, and Julian, we do the IG checks and bank statements. In cases where gifts are made, we ask for statements from the relevant party and establish their current circumstances. So, Julian, so let's assume you're acting for me on a purchase of a flat, right? And I say to you that I've got, and my father's lending me £25,000 in connection with a £50,000 deposit. Are you, when you say statements, are you asking for my father to write to you confirm I'm lending in £25,000 for the purchase of flat 6, Belfast, or whatever it is, yeah? Or are you saying statements you'd want father to provide you with a bank statement showing where that £25,000 is currently sitting? And would you then go further to say, right, father, you've then got to prove how you amassed that £25,000? And would it matter whether I was an old client of yours, regularly using you for acquisitions, and where father has provided funding for, a buy-to-let investment in the past, or not? So I think I'm interested in Smart Search. So I think we'll make some inquiries. We might get them to come along. Yeah, bank statements. Okay, right, got you. Julian, if father says, it was amassed from income, you wouldn't say, can I see tax returns or anything like that? Is that going a step too far for you, Julian? Patricia, years ago, as a matter of course, we'd have asked that if they were parenting, but now they're reluctant to say they've given it to info and mortgage advisor and have to insist they give it to us. Yeah, it's a problem, isn't it? I'll tell you what really annoys me, Patricia, that, with regard to sources of funds and proof of funds and sources of wealth, etc. About 2 or 3 months ago, my partner and I went, and she was looking at buying a car, and she was putting quite a big deposit down on the car, and the car salesman was just in the process of buying a house, and he and I were joking, well, I was joking, he was annoyed that he'd had to provide all this evidence and documentation to prove where his deposit had come from, right? And my partner's intended deposit on the car that she was contemplating purchasing was more than the deposit that he paid. And yet I'm sitting there expecting him to say, well, can you prove where that deposit money's come from? And he just said, I don't have to do that. As long as it's coming from a bank account and going into our bank account, as long as it's coming from your partner's bank account into our bank account, there's no AML checks that are necessary. And I think that's just ridiculous, given the steps that we've got to go through. And Julian, don't know about you, but I'm finding some conveyancers are absolutely terrified. And again, Raymond, this idea of MLROs and other compliance roles in the firm, again, is pretty scary, isn't it? But I agree, Raymond, the very heart of all of this is know your client, isn't it? And again, Raymond, as far as the conveyancing process is concerned, there is an obligation on us to know the client anyway, isn't it? To identify client objective, etc. So to an extent, all of this is an extension of what we're doing. Josh is asking you, Raymond, do you tend to just carry out the UK individual check, or do you use the triple check, smart check, documentary functions? Yeah, exactly, Josh. That's what I thought. I just thought this is crazy. And this guy was, start with, was sort of moaning, and then was sort of laughing about how ridiculous it is. Yeah, so you're liable regardless. I get that, Raymond. But going back to this point about from that Josh asks, are you able to, use all the functions on Smart Search? Okay. So Raymond, as MRLO, do you, if I was working for your firm, do you look at everything and all my decision making, or do I just report to you? Yeah, Julian, I agree with that. And you pay an upfront fee and take it from clients. Okay, yeah. And do clients balk about that, Raymond? Because I see real pushback where you say, I need to check with a third party. I get a lot of pushback there. Okay. And, firms will say to me, what can you do? And I think the only thing you can do, going back to the retainer, is when you're onboarding the client, say, look, where funds are coming from, be aware that I will be asking third parties for evidence, etc., and make sure where you're relying on third parties to make sure they understand that they'll be receiving communications from me. So Raymond, yeah, look at anything solicitors aren't happy with. Okay, got that. Okay. That's fantastic. Well, look, we'll tell you what we'll do. We'll see if we can get Smart Search along and find out a little bit more about that. We might ask Equifax as well. But can I ask everyone that's using Smart Search, did you look at Equifax beforehand? I agree, Raymond. Teeing them up is the key. The client that gets that sort of request out of the blue, or worse, the third party that gets that out of the blue, I think is going to go bananas. Okay. Good. Right. So does anyone have any other topics they want to talk about? If not, I want to change tack and talk about some negligence claims. Again, I told you that I come from conveyancing from a horribly warped angle in that we look at disasters all the time. Okay, right. So first of all, interesting, a lot of the big insurance brokers that insure solicitors produce regular newsletters in which they highlight what are causing claims at the moment and what they envisage have the potential to cause claims for the future. So if you're interested, I can give you a link and give you websites that will give you that data, or I can probably get someone to come along to talk to you from an insurance perspective and say, look, folks, this is what's causing claims. But to be honest with you, I was just looking at something from Howden Insurance Brokers, who are one of the biggest brokers in the UK. just recently, and they were saying that it's the same old topics that cause claims. So I've got a list here: failing to adequately investigate title, failing to advise on adverse rights, rights of way, etc., easements, formal or informal, failing to advise on formalities, planning, building regs, etc., missing consents for change of use, failing to carry out searches at all, or reporting to clients on search results, disregarding important provisions in contracts, boundaries, failing to advise clients on boundary or boundary issues, or where there is boundary sensitivity, failing to report to clients the result of boundary investigative work. Has anyone used a land surveyor for boundary identification or investigation? I was speaking at a conference yesterday and talking to a land surveyor, not a chartered surveyor, well, a chartered surveyor, but a chartered surveyor that specializes in land and land disputes. And I was also talking a couple of weeks ago to a High Court judge that was basically saying boundary identification shouldn't be the remit of a surveyor, in that boundary identification is in essence a legal issue. And I thought that's a really interesting point. But the more you think about it, that's correct, isn't it? Because boundaries are identified by what was intended when the boundary was created. A line on a plan is really an opinion. Is really an opinion rather than any form of factual exercise. And I thought that's a good way of putting it. Raymond, when you're saying you've used one more the past 2 years than 20 before, that's a surveyor, is it? Land surveyor. Yeah, it seems it's a boom area if you are talking about. So I'm just talking about boundaries, Raymond. I'm just saying, when you say I've used one more the past 2 years than 20 before, is that a land surveyor, or is that something else that I've missed? Land surveyors, yeah. Because, I guess in Northern Ireland with rural properties, it's the same sort of issue. Yeah, a mapper. Yeah, that's what I think. And as I say, this guy called Nigel Clayton, actually, was a barrister and a High Court judge part-time, sort of specializes when sitting as a judge in boundary disputes and boundary issues. And yeah, I agree with what Raymond's saying, that it's a hot topic, isn't it? Does anyone know why all of a sudden boundary disputes are an issue? Do you think it's because people are aware more of their entitlements? Is it because boundaries are all of a sudden more important? I don't know. It's odd, but certainly of cases that I see, and issues or problems with cases that I see. I knew that, Raymond, about the land registry not fully completed. Yeah, and I guess particularly in rural properties, there might be some time before we do have full completion of land registration. In England and Wales, there are 4 million properties currently that remain unregistered, and that causes issues. But I think registration doesn't necessarily resolve the problem, does it, Raymond? Well, I'm just waiting for Raymond on that one. Just looking at other negligence claims, this issue of boundaries, failing to register mortgages or charges, and failing to follow lenders' instructions. All right, you're trying to be polite. Well, it's very kind of you, Raymond. I'm delighted to that, because I am rather delicate. So your being polite is really helpful. Thank you. So yeah, I was just looking at this, and this was an article about negligence in conveyancing transactions in Northern Ireland. And I think in what I was reading, someone in Northern Ireland latched onto this case. I don't know if you've seen it. Case called Harry against Curtis Law. I'll just put it in the chat box. It's an English case. All right. Josh. Yeah. Okay. Get it. Yeah. Yeah. Lots of it was same here. Ray and Josh. The land registry here is, to be brutal, a bit of a laughing stock. Applications for first registration, 3 years, sometimes more. Land registry officers that don't understand land registration. And the curious thing about the land registry in England is that the land registry is looking for new tasks. And I do work for the Land Registry in England and Wales, and you know they're on to me at the moment about what else can we do. And I keep saying I don't want you to do anything else. I just want to get better or become competent at what you're supposed to be doing, but they don't seem to look at that. Anyway, while I'm waiting for Josh, this case of Harry against Curtis Law, 21st of March 2022, is really interesting because you had a lady that was buying a new build property suing her solicitors alleging negligence. And the negligence they said was, she said was, you didn't tell me that there was a trunk road that was going to be built in the vicinity of the property. Okay. And she said that as a result of their negligence, the value of a property declined, and also she was suffering from distress. She alleged that she should have been told about the proposed construction of a link road and that there'd be degradation of the environment, and she'd suffer loss of amenity. She said that she was particularly vulnerable to sort of road noise. She was very susceptible to noise, etc., which was the reason she was buying this property. Hi, Mark, if you've joined us, thanks very much for coming along today. It's nice to hear from you. So, yeah, in this case, what the judge said was, well, look, the firm's retainer, there's a word that we've just been talking about, was quite brutal in what the firm was saying they were going to do. They were operating on a fixed fee, and they made it quite clear that the firm wouldn't be giving advice about wider road development schemes in the locality. All they would be doing is a local land charges search, which would reveal development contemplated within close proximity of the property. And the other thing the court said was this claimant was putting pressure on the solicitors to complete quickly so she could get an incentive that was offered by the development. And the court was asked to consider if it was within the scope of the retainer or duty of the solicitor's advisor acting to advise the claimant about the proposed construction and location of a link road. And the court said, well, we've looked at the retainer, we've looked at the extent of the claimant's knowledge about the development and public information about the link road that had been provided to her by the builders that were building the property. They looked at the effect of time pressure that was being imposed on the firm by their client and the low fixed fee. And the court said was, in those circumstances, the defendant firm wasn't negligent and the client didn't make out her claim. So really interesting case. If you have a chance to look at it, Harry and Curtis Law. If you're really interested, I can send you a case report relating to it. Right, yeah, Josh, just learned the English language. I did used to think they were awful, but that is a lot more difficult. Is it really a lot more difficult or worse, Josh? Or and how is it difficult? I mean, I have to say, with the forums in Scotland and England, the language do come along to them. Yeah, I will send you that, Patricia. If you send me an email, I'll send that across to you happily. I'll give you my email address again, just in the chat box. There you go. So yeah, happy to share that. Take longer, rather very excuse. Yeah, yeah. Well, that's the same here as well. Requisitions, Josh. You know, they'll requisition you for anything and everything. Yeah, Josh. I mean, one of the things the Land Registry in England and Wales were looking at was digitization of the conveyancing process and of land registration. In part, it exists. I appreciate you don't have online registration with the Land Registry in Northern Ireland. What about electronic signatures, Josh? Do you encounter those? Right, okay, so just go back to that negligence claim. The other thing that was interesting in Harry and Curtis Law, this lady saying, well, you know, I'm vulnerable to road noise, etc. And the judge said, well, yeah, but you didn't tell your solicitors that. You didn't say that your objective in buying this property was the property was in a quiet location. You know, had you done that, then the firm might have had a more expansive duty to you. Again, the thing that was interesting there is that the judge didn't say, you, Mr. Solicitor, should have asked your client about their objective with regard to the acquisition, which I thought might have been a sort of an argument that was put forward, but that issue wasn't tested before the court. Again, Harry and Curtis law, cheap conveyancing fee was a significant factor. A retainer that was brutally honest about what was being done and what was not being done as a consequence of a reduced fee. Again, important. Okay, right. Some things I've just been digging up with regard to the Northern Irish Court of Appeal, case called Young against Hamilton. Ownership of rights of way. Are you familiar with that one, anyone? Young against Hamilton, 2014. Northern Irish Court of Appeal. And misrepresentations on the part of the seller made by their solicitors. And an allegation of negligence against the purchaser's solicitors to pursue adequate inquiries. Really interesting case, this is, which is something I've been working on recently. As part of due diligence, if you're acting for a buyer, your task is to identify risk and identify issues, and in hoping to identify risk and issues, and in dealing with them each or both, risk, I think all your task is to highlight to the client the existence of risk, and other than issues in title, you're not expected to quantify or assess or determine the extent of the risk. You're just drawing it to the client's attention and then telling the client what steps or measures can be taken to quantify or identify risk. As far as issues are concerned, due diligence might reveal issues that remain outstanding. And I think your task is to highlight to the client the fact that there are issues outstanding and what steps or measures you or the client or a third party could undertake relating to outstanding issues. So that case of Hamilton, Young against Hamilton and others, 2014, sort of confirms that position. Again, have you all seen that or not? If you haven't, again, I can send you, or next time I can make available to you the notes I've got relating to it. It was concerning a right of way, to be honest with you. And again, the other thing that I've looked at are handbook negligence claims brought by lenders against solicitors where solicitors have not complied with their obligations in the CML handbook. Capital Home Loans and Hewitt and Gilpin solicitors, 2016. Have you seen that decision? And there's another one I was looking at earlier. I can't remember where it is. Yeah, Hickland and McKean, 2018. This was an interesting case. Have you seen this one? Hickland and McKean, I hope I've said that right, 2018 decision, decided on 26th of October, 2018. An unsophisticated buyer in a domestic conveyancing transaction should have had unusual features with regard to the property's title explained and addressed. So purchase of an apartment with a flying freehold, and the allegations brought by the plaintiff, failure to advise as to the problems involved in purchasing a flying freehold, failing to explain to her the implications these problems would have on her with regard to ownership, failure to ensure that the client understood the advice that she was given. So in this case, the solicitors acting identified that there was a flying freehold and said that they discussed this with the client and that she fully understood what she was told. Well, the problem here was it's all well and good explaining something to the client and you thinking as a lawyer that the client understands it. Have you got evidence on file to confirm that they do understand it? And in this case, which is a Northern Irish case, there was reference to an English case called Minkin against Landsberg, which is a case I'm very familiar with concerning conveyances negligence in England. And what happened in that case, which was a Court of Appeal decision, the Court of Appeal set out some basic principles which are worth looking at today, to be honest with you. Solicitor's contractual duties to carry out the task which the client has instructed and the solicitor has agreed to undertake. So that's the retainer issue that we've explored earlier. Implicit in the retainer that the solicitor will offer advice which is reasonably incidental to the work that he or she is carrying out. So anything that's incidental to the retainer or that which the client has asked you to do needs addressing. That's something called the adjacent tooth principle. It's sort of a dentistry term. If you go to a dentist with a bad tooth and the dentist inspects your mouth and sees there's another tooth that's decaying or whatever, he or she's under an obligation to explain to you the defect in the tooth. They're not required to sort of focus in on the tooth that you're complaining about. Basic point, but again, expanded to the world of us as conveyancers. In determining what advice is reasonably incidental, this is the interesting bit, necessary to have regard to all the circumstances of the case, including the character and experience of the client. So note there, the character and experience of the client. So you're required to gauge or to target your advice and explanation to the client. Now, that sort of flies in the face of a standard form of report on title and etc., doesn't it? Because that's saying to you, you've got to personalize the information that you're generating for the client. Does that mean that you can't use precedence reports on title, etc.? I don't think it does. I think it just means you've got to be careful. And I think the key thing is to make sure that where you're giving advice or explanation to the client orally, that's supported by an email or a letter thereafter or a report thereafter confirming what was said and confirming what further steps were being undertaken. What I'll do, I think, is I'll try and condense the Minkin case into a sort of case report for you, and we'll have a look at that. Got the name of it. Yeah, Hickland and McKeon case, 2018. I'll try and put a report together for that for you, if I could. Okay. So again, there's just some really interesting stuff about, how to avoid negligence claims. I always say to practitioners, to avoid a negligence claim, do the simple things well. And when we're communicating with a client, remember, communication is a two-way process. So you're providing information to the client here. You want the client to confirm they've received that information and they've understood it. So I say when you're submitting a report to a client or you're explaining an issue or a risk to a client, you ask the client to confirm that they've received your communication, that they've understood the points you're getting over, and that they don't have any questions or queries. And where they do have questions or queries, that you deal with them. And again, you deal with them in writing, in my view. So yeah, interesting stuff on that in that case. Right. Case called Baird against Stephen Hastings, 2015 decision, again, Court of Appeal. Anyone seen that one? Can I ask, do you have anything that provides a sort of an update? I know I've seen the Law Society sort of newsletter, but do you have a sort of conveyancing update sort of publication for resi conveyancers or commercial property lawyers? I can't think of anything that I've seen in Northern Ireland. I mean, the Estates Gazette is probably the nearest to it, but the Estates Gazette doesn't really focus in on Northern Ireland to any degree, does it? And certainly its case law update sections aren't relevant to Northern Ireland. Again, it's something I'll have a look at, I think, to be honest with you. But I will, given what you said, Patricia, I'll put some of these out. Where I've got a case report, I'll send it to you. Some of these other ones I've just been digging out and having a look at. Again, I'll try and get someone to produce case reports and make them available to everyone. I am conscious of time, however. Has anyone got anything they'd like to look at next time? Because I think we've got a minute left before we're due to finish. Anyone got any topics for next time?
I would just butt in here, Ian, and
yes,
say,
John. Hi, John.
We in Scotland, we've got Scottish Legal News, which gives us some case law and etc.
Yeah.
And I also believe there is an Irish equivalent, Irish Legal News. So it doesn't cost anything. Might be worthwhile. I believe it's still going. It might be worthwhile signing up to, because it gives you some case decisions. So just if anybody's interested in that.
Fantastic. Thanks for that tip. That's fantastic. Yeah, I'll do that. Okay. So does anyone have any topics for next time? Has this been useful? And is there anything you'd like us to incorporate? I'm very keen to get people to come along and speak. Josh, Patricia, thank you so much for that positivity. That's really kind. And a massive thank you to Stewart Title John and Liz and Jenny and Robert and the team at Stewart Title, I can't tell you how supportive they are of the legal profession. Have a look at the website. Do talk to Liz and John about, you know, the need for title indemnity insurance, and do have a look at the website. But thank you so much for coming along today. Yeah, co-ownership forms. I did, Patricia. Sorry about that. Yeah, I'll get it across to you. And I've also got some like a little sort of I don't know, route map. I describe it for co-ownership. I'll get that available, Patricia, as well. All right. Well, listen, everyone, have a lovely day today. Thanks so much for your time. I really appreciate. Fantastic, Julian, Patricia, everyone else. Really, really enjoyed it. See you soon. See you next time. Cheers, Raymond. Really thanks for your input today. Patricia, no problem at all. All right, my friends. Speak soon. Thank you. Bye-bye.